Hi, my name is Attorney Kern Singh and I'm a founding partner with the Singh Law Firm. Today's segment is going to be on what is probate and why is there such a probate system when we pass. Probate is a court-administered process that begins when we pass if we have probate triggering assets. And probate triggering assets are real estate or bank accounts. And if you have bank accounts, let's say they're your checking, savings, your trading accounts, and the cumulative value of all these assets combined is $150,000 or more, then there would be probate on your bank accounts. And if you have real estate, there would be probate on your real property as well. So what's probate? Well, when we pass and we don't have a living trust, and maybe we have a will, maybe we don't have a will, but we definitely don't have a living trust, and we have one of the other or both, real estate, bank accounts, checking, saving, trading accounts, and we've passed without a living trust, then unfortunately when we pass, our children, if they're adults, our brothers, our sisters, or someone else on our children's behalf cannot go to the bank and tell the bank to release the funds, even if they went to the bank with our children's birth certificates, with our death certificates, and told the bank, look, Kern, Sharmila, they've passed, and unfortunately they've left behind these children, and I've got all the documents showing that these are their kids and the death certificates here in hand. Can you go ahead and release the funds to me? I'm the uncle for these young children, and I'm going to manage this money for the kids. It's not the bank's job to figure out who all the beneficiaries were for the decedent. Their job is not to figure out who the beneficiaries are, who did the decedents owe money to, who are all the debts out there, who owed money to the decedents. It's not their job to authenticate any of this information. So the bank is going to say, well, unfortunately, we're very sorry for your loss, but you know what? Since there was no living trust, you're going to have to go through the court process of getting a probate opened and having the court administer this and figure out who all the intended beneficiaries are. But until then, we're locking the accounts. We're not going to allow anyone to have access to these accounts. And the same thing would happen with real estate. So with real estate, you have title, there's a deed, and the deed will show who the title owners are. And again, same facts, people have passed away, the children who are adults, or maybe someone on behalf of the children tries to sell the property. Now, with real estate transactions, you have sellers, you have buyers, and in the middle of them, you have a title company. And the purpose of the title company is to check title on the property to ensure that the person selling the property actually has that right. Well, unfortunately, when you're gone, no one other than you have the right to sell that property, especially if it's not in a trust. So here, in this exact same example, when you pass and your house is not part of a trust, no one has that authority to sell the property. So the title company is going to say, well, unfortunately, the title's clouded. We're not going to allow anyone to sell this property. Go through the probate process, get the court's approval for us to transfer this asset to whoever the intended beneficiaries are by law. So here, now we've hit a brick wall with our real estate and our bank accounts. And what probate is now someone has to petition the court, file a probate in the court, let the court know that these individuals have passed. There's going to be a whole slew of hearings. There's going to be accountings done. There's going to be investigations as to figure out who all the true beneficiaries are. Notices need to be sent out. There's going to be also, in addition to all that I've mentioned here, there's also going to need to be identification of who all the true beneficiaries are. So this probate process with all these hearings and all this investigation that needs to happen could take up to a year, 2 years, sometimes longer, depending on how complex the situation is, if there's any litigation going on in between. But just imagine this, you've got probate court, which could take 2 years or longer. There's court costs, which you've got attorney's fees, which are set by California statutory schemes. So those are already set by law. Then you also have court costs, which are built-in expenses as well. Then you're going to have potential litigation that could occur, people coming out and saying they're relatives or children and they were owed money, and that could drive up the fees as well. But more important than all that, then with all this hullabaloo, your family's being shuffled back and forth through court, so there's that hassle as well. So the time, the expense, and then at the end of all of this, your children who might not be ready to inherit this money would get that money if they are of age. And the problem there is if your kids are not mature enough to handle funds, they may end up squandering the money away. So unfortunately, probate doesn't leave us much choice. It's a big burden. It's a big hassle for your family. And so the idea with setting up a revocable living trust, that allows us to avoid this probate process. With setting up your living trust, you'd have your assets transferred in, all your probate triggering assets like real estate and bank accounts, so that when you pass, you have a line of individuals who are called your successor trustees who would be able to step into your shoes when you pass and then approach the banks and tell the bank, look, these individuals have passed, we've administered the trust, I am now the successor trustee on this trust, I need to get access to the money so I could use this money to pay for bills or expenses of the children. And then when the children get to the age that the original settlors had defined in the trust for them to attain, that's when the children would inherit the money out of the trust. And then with real estate, same thing would occur. If I needed to sell the property as a successor trustee on a trust, I would have that authority to do so because the title of the property would be in the trust. The title company would allow me as successor trustee to sign off on that document to sell the property to a new buyer. So in this situation, again, there's no court involvement. I, as the successor trustee, would have that ability to do so for the original parties. So here, it's a seamless transition. You don't have that burden of the court process involved. I hope this segment was helpful to help you understand what the probate process is quickly. I wish I had more time to discuss it at length, but if you'd like to understand more about probate, more about how to avoid the probate process, you can visit our website at www.singlawfirm.com, or you can also call us and schedule your consultation to understand more, or visit our website to look at the different videos or blogs we have on these topics as well. Thank you for watching and have a wonderful day.